stuff like that. The one I want to talk about, because there's a lot of documentation that goes with it, and it's kind of cool when you're writing an operating agreement. So I have a couple. These are all examples of things that we actually used in different cases. You know, these are three stories that I was involved in. You know, in this scenario. So the concept that we're gonna try to work with, the easiest concept is when to keep a business open on Shabbos, we're going to first of all be maktim. We're talking about a business that basically needs to be open on Shabbos. It's the type of business that can't really close. So, for example, you have a nursing home, very Jewish business, and obviously it needs to continue running on Shabbos. But you could also have more retail stuff where, for example, a Ventura Mall and these things, there's certain places you can't close on Shabbos. It's part of the lease of the place you're in. Could be certain things like that. You need to stay open. Or, for example, you have a gas station. It's not feasible to run. If you would have to close it on Shabbos, you wouldn't be able to own the business to begin with. It's not a type of business that can run, but if it's closed on Shabbos. So, what's a way to do it? So there are certain things to be done, but the method that I want to discuss is talked about in Orach Chaim Sim Rish Mem Hey, and it's when you have a partnership with a non-Jew, a shutfus with a non-Jew. So let's talk, for example, first a case that there's a Jew and a non-Jew who are going to own the business together, for real. So they have a shutfus, and before they start their partnership, they make the following arrangement. So they say, look, okay, actually, one more hakdama, one introduction piece before that, is that there's two potential problems. There are two potential problems with running your business on Shabbos. The first potential problem is that the people are working. You're not allowed to have a non-Jew or anybody do work for you on your behalf on Shabbos. So if you're running the business, all the employees are working for you. So the employees are working for you. That's the problem. You're not allowed to have the employees working for you on Shabbos. That's problem number one. Number two is that you're making money from the store being open on Shabbos, especially in a retail where there's actually money that comes in on Shabbos. In a nursing home example, that's probably a little bit less of an issue because the money's not generated on Shabbos. But there's an issue, even of passive income, to make money on Shabbos. There's actually an interesting tshuva. Moshe Feinstein writes that on Yom Tif, Reb David, his son, Reb David Feinstein, asked him a shaila. That we discussed this one year, maybe you were there, that you shouldn't be allowed to keep interest that you make in a bank that comes in that's generated on Shabbos. Interest that comes in on Shabbos should be a problem of schar Shabbos, and there's even passive income, but you're making money on Shabbos. So Moshe writes that's not a problem because the way the banks pay you the interest is it's accrued over 24 hours. So therefore, it's b'havla. It's considered partially not on Shabbos. Motzei Shabbos. Yeah. So you have, so you're accruing it from Friday night 12:01 till 11:59 on Saturday. So that portion is not Shabbos. It's after Shabbos is over. So that portion it is. No, but that's okay because it comes in as one lump sum. 0.01 cents, that you made. So that comes in at the end of the day. So therefore, once it comes in as one lump sum, you can't. It's not considered coming in for Shabbos specifically.
3-day Yom Tov.
So this year, 2-day Yom Tov is a problem. Because Shabbos and Sunday, if it's a 2-day Yom Tov, it may not be a problem because only one of the days is really Yom Tov. But when it's Shabbos and Sunday, so it could be that you should go into your account and figure out a 1/30th of your interest that's accruing, and it could be that's Schar Shabbos.
And you give that to tzedakah?
So if you give it to tzedakah, you have to give it anonymously. Otherwise, you're benefiting from it. You're getting covered or whatever.
I'll close my eyes.
It doesn't matter that it's paid out once a month?
That doesn't matter because it's generated, because theoretically, if you close the account, they would give it to you prorated, right? So.
Well, what about the people that work specifically on Shabbos at shuls, like youth directors? If people come in And
Yeah, it's not so partial.
not like a shul rav, because obviously they have a year-round job, but there's some
Right.
people that like specifically come in and watch.
So
children
theoretically,
on
you're
Shabbos.
paying them for their preparation and stuff like that.
Okay.
But the Rav said it's not an issue because they're not doing malacha.
And well, no, but it's Char Shabbos though. It's not malacha, but it's Char Shabbos.
Oh, that's okay. That's
No,
what I
but the
was-
goy doesn't matter. You were asking about the cleaning lady. You're allowed to pay her. She's allowed to make money on Shabbos. Your problem was that she's working for you. So I'm saying what she's doing for you is not malacha. That was that conversation. that was a different. You know what I'm saying? Okay, but the model that I want to discuss is this partnership issue. So to address both of these problems, so you have a partnership with a non-Jew. So how's it set up? So the way you set it up is that the Jew, you tell them like this: there's 7 days a week. We're open 7 days a week. Monday through Friday, we own the business 50-50. That means everybody working is working for both of us. All the profit that's generated is generated for both of us. Saturday, the business belongs entirely to the non-Jewish partner. And Sunday, the business belongs entirely to the Jewish partner. And all the profits of Saturday will come to the Jewish partner, and the non-Jewish partner, and on Shabbat and Sunday will go. Yeah.
Even if it's not even.
Okay. So now what you could say like this. You could say, and then you say, the accounting of this may, if either party decides or chooses that the accounting this is too expensive, maybe complicated to figure out exactly what came in on Shabbos Sunday. Either party could choose to just split split the total profits of the month 50-50. So you're going to put it in there. It probably is better if you put it in the court of the non-Jewish partner to say, I'm not interested in doing the accounting. I'd rather just split the profits 50-50, and you would accept that. So at that point, theoretically, they could decide, I want to go look into it. I want to go look into the accounting exactly. But if they choose to forego it, you could just split everything 50-50. Okay?
So the fact that they have the rights is enough to.
Yeah, because it's theoretically that's the way it is. Okay. Now, this was done. This was done in this scenario. It was very, very. Now, for the fact, sometimes you would want to just give them something for it. So in this case, they said if you foregoing the accounting, we'll pay you $1,000 over the year. So just like a token thing. And so this was an example of a contract that was. Now this was good because this case, they were actually 50-50 partners. Okay, where this gets tricky is, okay. So I brought an example of this, and this is an addendum. This was a real business, and this was written as an addendum to their what's it called, partnership agreement. Okay, so this is a very simple one. This is the most simple arrangement. Okay. I took at the names, obviously. We, Jewish partner, non-Jewish NJP, are forming a partnership under the name of whatever it was. The parties are partners in the company as per an existing partnership agreement. On the Sabbath and Jewish holidays, the whole place of the business belongs to NJP. The whole expense and earnings of Shabbos and holidays belong to NJP. JP has the right to the profits of one weekday for every day taken by NJP during the week following that of Shabbos or Jewish holidays. The rest of the days of the week will be split as per the existing partnership agreement. If they choose, she was a woman, I guess, may forego an accounting of profits and demand a settlement fee of $1,000 per calendar year or 0.05 of the profits. So this way you're just kind of giving them an incentive, just forego it, and then we'll split everything 50-50. And then the paragraph 2 discusses the work. Okay, the duties of what's the responsibilities and the duties and all the work on employment.
So you're paying him $1,000 to possibly keep stuff that you earned on Shabbos.
You're paying him $1,000.
And in return, he's not going to make a claim on you for something that he earned on Shabbos that he should have kept more. You're buying the.
You're basically telling him, look, it may be complicated to do it. If you choose to forego it, there'll be $1,000 incentive for you to do that. Then why would you want him to forego it? You're saying?
No,
because it's complicated.
You're purchasing the time on Shabbos.
Not really. No, because they could still decide to go through the accounting process. But the accounting, it could be that what's easier. I was going over this with someone else. It's probably better to just say the accounting of this would have to be done at the expense of NJP. So then they could choose to do it, but they're not going to want to because it's very expensive. So you don't even have to do that.
Not paying them.
Instead, you just say the accounting would have to be at their expense. Okay. So this is a very simple one, right? And it was written as an addendum to the agreement, and it was done. Okay. There's two potential problems with this. One potential problem is that not always do you have a partnership with a non-Jew that's 50-50. Sometimes it's structured differently. Or it's not even a partnership b'chlal. All the partners are Jewish. So at that point, what do you do? That's problem number one. You don't want to just give them 50% profit. Well, how do you do that? But the more important problem is that generally speaking, like what happened to me not last Friday, but 2 Fridays ago, people call you up. A guy calls me up on Friday. We're going into holidays. I realize I have a store, a retail store that's open. I have a partner that happens now to be Jewish. We're not closing on Shabbos. So what do I do? I said, well, I don't know what to do because it's 4:00 on Friday. But besides that, there's a bigger problem. This thing doesn't work once you're in the business. This works before you start. So before you start, as part of the partnership agreement, that's why it's important for who's ever drafting partnership, agreements to know this. If you want to look out for them, so this is something you have to draft before. If the agreement has already been entered and the business is working, so you can't do this anymore. Why? Because now essentially what happens? It becomes my business. It's the Jew. Imagine it's Ruvain and John, whatever, right? So Ruvain is responsible 100% for the business on Shabbos. Now, what's he telling his partner John? He says, John, hey, how about, do you mind taking over Shabbos and I'll take over Sunday? So essentially what John is doing is he's working on behalf of Ruvain to keep the business going. And payment for that, Ruvain says, I'll work for you on Sunday. So since when they started the business, they didn't make this arrangement, it's too late because now Ruvain owns the business for Shabbos and anything that happens afterwards is already his shlichus. Whatever who's ever doing it is doing it as his shliach. So he has to remove himself from the business prior to ever owning Shabbos. That's the trick. So if you do this before, you're in good shape. Same thing with the heter iska. If you sign it before, you're good, but if not, it's a problem. So that becomes a very big problem. So
Because here you never owned it to begin with.
Exactly. So if you never owned it to begin with, that's fine, great, it's your business. But when you do own it, and then you have to figure out how to remove yourself. So the only thing I could tell him, I told this guy that called me, I said, you can call up the guy, call up your partner, say, as far as I'm concerned, the business, I want to close the store on Shabbos. I don't want any of the profits that were made on Shabbos. I don't want to have anything to do with it. And it's up to you if you want to keep the store open. And you can keep the money. But then he's not getting anything. He's actually going to lose that money then. If you, in the other scenario, if he would have done it before, he could have gotten Sunday instead. He could have still retained 50%. Now he can't do that. It's too late.
If you don't do it before, effectively you are losing the 7. Meaning, or I guess you're no longer
you're
50-50.
You're going to have to lose that 7th. Now, he could pay you for the expenses. He's selling retail items that we own together. So my share, if you sold it, then you could pay me back from, the principal investment. But you can't make money.
You're allowed to not lose.
Yeah, a guy doesn't have to walk into my store and take my stuff. But I can't make any profit on that. So I told him that's what you could do. There's nothing else to do.
You didn't hear back from him, did you?
What?
You didn't hear back. He's like, I can't hear you. Calling the different guy.
Yeah.
So you dissolve the partnership and then we.
Yeah, but if you have a real partnership agreement, you have to ask these guys. I don't know. It's not
If you dissolve it and just enter another agreement an hour later?
Yeah, we'll just dissolve it. Okay, we're done.
Okay,
That's
it's complicated.
kind of like fiction, but I guess all this is kind of
Well, right. Theoretically, this is all. And Moshe Feinstein says you can only do this in business that makes sense to do. Whatever that makes sense to do it in others. But
what do you mean?
that you could actually figure out the profits that would come in on Shabbos. If you have a business that's just impossible to figure that out, you can't write this stuff. You could do it in a different way, Okay, so regarding the first issue, when you're not 50-50 partners, I had a very interesting case. This is a case, I guess I have the date here, it was 2017. Very interesting case. The case was, the copy didn't come and got on the site, 2019. The case was basically, there were 10 people that they were partners. 8 of them were Jewish, 2 of them were not Jewish. They were buying gas stations. Okay? So they had to figure out how to keep it open on Shabbos. So we made a cheshbon with the guy, and we said, how many days are Shabbos? 52 days of the year. How many days is Yom Tov? So Yom Tov is 2 days Rosh Hashanah, 1 day Yom Kippur. Once you're doing it, you may as well do Sukkot the whole Chol Moed. Why not? So let's say that's 9 days. So 9, 10, 12, plus 8 days Pesach. So it's 20 plus Shavuot is 22 days. 22 plus 52 is about 70 days of the year. So what percentage is 70 out of the year, out of 364? It's about 20%. So what worked out was that the 20% that, remember there was 10 partners, 8 of them were Jewish, 2 of them were not. So the non-Jewish portion of the partnership was about 20%. So basically what we told them was, why don't you actually do a real partnership and attribute the 20% of the profits to the Shabbos and Yom Tov? And basically say they own Shabbos and Yom Tov and you own the rest of the year. Now again,
That worked out there.
That worked out perfectly in that particular scenario. And again, you would put in a clause that what's it called? You would put in a clause that if they don't demand the settlement, they could just demand 20% of the profits. Okay, so this is what we did in this case.
Shabbos and Sunday are probably more profitable.
So it says here. It says if they choose, they may forego an accounting of profits from their share in the business and demand a settlement of 20% of the total profits earned by the calendar year.
I'm just saying, if I were them, I'd go take it.
So I don't know in the gas station
Or
business.
at least try it. Try one.
I don't know. Gas stations could be. There's a logic that's for carrot.
You created these?
What?
You guys created these?
Yeah. I was reviewing. There's another whole interesting part to this case, which if we have time I'll go over. But it says I'm Mr. Planey, whatever, acting on behalf. So I kept the names of the non-Jew. I figured no one knows, Rafael Carrera and Francisco here. So whatever. The parties are partners in the company as per an existing partnership agreement, but the extent of the partnership is delineated in this addendum. So Shabbos and holidays, the whole place of the business belongs to these 2 people. They may decide on their own to open the business or close as they please. All employees are working on Shabbos for them. The whole expense and earnings of the Shabbos and holidays belong to them. And those he is, period. The Jew, and those he is representing are the owners of the other days of the week and have the rights to profits generated by the company for the rest of the week and non-Jewish holidays. Okay. Now, if you look in the middle of the second paragraph, it says, however, the Mr. Carrera and Mr. Hanhausen cannot do anything in the facility without the permission of the Jewish partners above what their rights are per their partnership agreement. Because otherwise what what will happen is, potentially, is on Shabbos, all of a sudden, hey, we started remodeling. It's our business today, So they can't do anything above the partnership agreement without permission, but anything that would affect the rest of the days of the week. Okay, so that's how
They're working the rest of the week, though. So during the rest of the week, they're working.
I don't know that any of these people are working. I could be they're just owners. And then it says if they choose, they may forego an accounting of the profits and demand a settlement fee of 20%, which is equivalent of their portion in the business. Now, what we're saying is they may decide, hey, I want the Shabbos Yom Tov, but of course, just let them do that. I mean, again, like you're saying, we're not supposed to make money from Shabbos and Yom Tov, so they should be able to demand that. So this is actually pretty straightforward. This one was also pretty straightforward.
Can I add one thing that in the future you could do? Is because I'm just curious, I'm thinking how this would work in a secular case. Like if somebody had a partnership and then somebody comes with a document like this, says, oh wait, you're entitled to 20%, but like if you make it,
You have to add language here, yeah.
That says you have 10 days to exercise your rights to do it, because after that, then they know it's out. Because he can say, I'm exercising it now. 2 years later, when they're in the litigation, that's when he can decide.
Okay, so in the next one I'm going to give you, it has a lot more of that stuff. It's much, much more detailed.
This could be a whole new revenue stream, a partnership between the firm and the co certifying
Well, that's the whole point.
Right.
Yeah, I mean, that's yeah. You know, you have your. I remember I had this shotness. I had this shotness in my jacket. So I have an uncle that's not observant. So he's like, "What's with you? You're closing the hashgacha also now?" It's like, you go certifying up every business. Anyway, so you're right. No, so these are very, very basic. You know, these are very basic. By the way, there's a whole nother part of the gas station, which I was not aware of, which probably you guys do know, is that in the gas station business, you make more money off the store than you do off the gas, apparently.
Yeah.
So the little store over there,
That's surprising.
yeah, I wasn't aware of that. But this guy, that's what he told me. Now, in that particular store, in that particular gas shop, they sold a lot of stuff, and including sandwiches and like real food also. So there's a whole nother part of this, which is, you know, you're not allowed to make money off non-kosher food. You're not allowed to do business with non-kosher food. So in addition to this, what we added on was that they own all the non-kosher foods in the store, and the the 80% Jewish partners own everything else in the store. And again, the same thing. If you choose to forego the accounting, then you could choose a 20% settlement in whatever revenue comes in from the store.
But was it actually 20%? Because isn't that
That's what he's asking. You know, if they would choose to do the accounting.
No, but I'm saying if it's not actually 20%, let's say it's 50%, isn't that a problem?
Right. This was much more accurate because it was literally 20%.
Isn't that
There,
more of a problem thing for getting hana from non-kosher food?
well, what you're saying is they own that part of the business, and they could choose to forego the accounting and take
Okay.
20% of the revenue. We actually had to add more than 20% of the revenue. But we had to say basically that they own all the non-kosher and the chametz on Pesach. So, you know, the partnership was like, you know, set up in that way. But that for foods types of partnerships, you have to figure out Pesach, non-kosher.
Once there's a talk about stock ownership, and
Right.
this would obviously come up with if you have a company.
Right.
I don't know if you discussed it in your last.
Right,
year,
that was a whole
company.
complicated thing about what's the nature of owning stock
Yeah.
or of company. But this was not stock. These
Yeah,
guys own the store.
No, I was just thinking of like the non-kosher food example because there's
Yeah.
tons of companies, obviously, that are publicly traded that
Right,
you know.
right.
do
All your
non-kosher food.
stock in anything.
McDonald's.
Yeah.
Even though they're like a real estate company, really, not a food company.
Right, but I'm saying even Target. I mean, any at retail, keep
Yeah.
on is selling
So,
chametz.
so the stock thing, both for Shomer Shabbos and for Shabbos,
Is
and
it-
Shabbos,
is
doesn't pierce the stock ownership.
Right. I mean, the basic concept that we said last time was that if your stock is so minute
No
that you don't have control, then it's not a
You still
problem.
get benefit. It's
You
not
get
all-
benefit, but there's also they are selling other stuff. So you're not mechuyev to attribute your benefit to that, and you're not doing business on Shabbos. And the chametz part is a little,
It's
trickier.
not-
Yeah,
it's
yeah. Okay. Now, what happens, which is a little more complicated. Now, as you can imagine, what happens in a case where you don't have a non-Jewish partner? So you have to basically bring someone in. You have to take one of the employees and do something, figure out an arrangement. So this case was a case. It was a business that it runs out of Aventura Mall, and they had to stay open on Shabbos. And it was 5 Jewish partners. They moved again. This was like I remember the story. They moved from out of state, and they just bought this thing. And then also it was like right before Shabbos, whatever, and whatever. And in the end, this I did not write. This is much more detailed. This I got from someone, but this is like a real document. This is like a real document. Has a lot of what you discussed, but the concept that they talked about is a little different here, because like I said before, these you can only do in the beginning. These you can only do before you start. But the guy that called me, he had already started the business. They already owned the business, and they were going into Shabbos. So he didn't want to lose Shabbos completely. So he didn't just want to give it away. And he didn't have a partner. There was no partners to give it to. So the way that was handled was that essentially you have to lease out. You have to basically sublease the business. You have to sublease the business for Shabbos and Yom Tov. That it's owned by, you're subleasing the business. Now, if you sublease the business, so basically what you're going to end up doing is you sublease the business, and technically what you try to do is you try to figure out that the price that the person would have to pay you is equivalent to the profit you would have made. Right? So they end up paying you.
Aren't you getting paid then for leasing something on Shabbos?
So you lease it for an hour before, an hour after. That's not a problem.
Who are you still have an issue with Marasayim?
What?
You still have an issue with Marasayim?
So if it would be Marasayim, it would be a big issue. Correct. The assumption is that no one really knows that this is owned by a Jew. It's just a retail store in Aventura Mall. It wasn't called Friedman's, bakery. Yeah. This was like, it was whatever. I don't get to details, but it was some retail store with a name that didn't have anything. It would not be a Marasayim issue because these were partners that no one knew. So who are you leasing it to? So they had to lease it to the employees in the business.
And they got a raise or something equivalent.
Why do they have to get a raise?
Well, otherwise it's a joke. How are they getting? That has to be something that reflects 1/7 of the profits. Right?
They could take all the profit technically, but they have to pay the lease.
Oh, I see.
So now you could tell them, basically, we'll be going for the profits in the place of the lease or something like that. But that's not exactly how we did it. So let's go over this together, because this is more. I may need your help to decipher some of this stuff, because this was written by attorneys. This was not written. I read it over, but there's a lot more language that protects all the sides over here.
I can see a problem from liability. Like if something happened.
Well, the one thing is that in Aventura Mall, you're not allowed to sublease space. So, okay, but let's leave that. Let's leave that for now. So we refer to as the lessers.
It's not usually, it doesn't make a sublease necessarily
Right.
invalid. It's just
Correct, exactly. Partners in that business located in Aventura Mall, Sawgrass, and wherever hereby enter into a lease agreement for our share in the above-mentioned businesses to the lessees. This agreement made on this day of 2023 by and between the lessors and the lessors hereby lease the company to the lessee for the following terms: each and every Friday from 1/2 hour before sundown to that Saturday 1 hour and 30 minutes after sundown. Going through Bina Tam over here apparently, and the Jewish holidays of Rosh Hashanah, Yom Kippur, Sukkot, Pesach, Shavuos, from the same point. Okay, the term of this lease shall be 12 months from the above date. It's $1,000 per day for each day that the lessee is leasing the business term. Now, the lessee has made a $10 down payment. Since the lessee does not have the funds for the full lease payment, the lessor has agreed to consider it a loan at an interest rate of 12%. I don't know yet why he did that. I have to go over. Well, let's go over and see what the point with that was. But at lessee's discretion, okay, lessee may either one or two choices. Okay, here's giving me two choices. He may require an assessment of the profits and losses for each of that day's business is leased, revenue reduced by expenses. Okay, the lease payment and interest on. So he could demand a real. Now I would right here, Josh, if you're doing this. In choice number one, I would put in at his expense.
To dissuade him from...
Yeah. So I would put that in there. So I don't know, they didn't put that in. Now number two, there's another, demand a settlement payment of $5 a day for every day that the business is leased in lieu of profits for each day that the business is leased. So it's kind of making it like, okay, we'll pay you $5 and don't ask us for the money.
You don't think that this would have an issue with being illusory? Potentially, if you wanted to enforce these in secular court, there's so many outs, and then it becomes like we're like neither side really does have obligations at the end of the day. There's options where you don't have to.
Well, let me see. Hold on. Let me.
Illusory promises that are
illusory.
Illusory. Maybe I'm not pronouncing it right. Like an illusion.
So if I make a promise to buy your house, but I have an exception unless I don't want to, it's not a contract.
Yeah.
There's no actual.
What if there's like a slip and fall on Shabbos? So the owners can say you have to sue the employees because we didn't know it was leased out.
Right.
There should be a clause in that.
Okay, so let's go through this. So lessee hereby trusts the lessor by lessor's word alone as to the accuracy of any assessment of profits and losses.
So I guess that helps with the...
That helps with no, but okay. Now here, Josh, this is your clause. If 24 hours go by after any day that the business is leased, then the assumption is that they're choosing choice number 2.
Take $5.
Right.
Okay.
Now, if they pay the $5, does that mean they don't have to pay the rent? I don't want to copy that part. Is that what they're saying? Because you're charging them $1,000 per day. So they may say, you know what, instead of paying the $1,000 and trying to figure out my profit, I'll just pay you $5 and leave it alone.
$5 a day in lieu of profits for each day that the business is leased.
But why would they pay $1,000 and get back $5? Doesn't make sense.
No, it's the owner's paying them $1,500.
What?
The lessee shall pay, not the lessor.
Right, that's the payment, but the second option is that the lessee can just say, pay me $5 and
From the lessor.
Right, he's going to be paid $5 for his profits. He's going to get $5 of the profit. But he's not going to pay $1,000 per day to get $5 of profit. I assume with that choice, what that means.
It's $5 because
they're probably estimating profits at $1,000 a day. That's how.
No, but 5 times 365 is 1825.
No, but that's only $5 per day of whatever the day was. Such indication shall be final. No, the settlement can be rounded up to $350 per year that the payments are made in no more than 4 installments. Basically, I think what they're basically saying is that if you don't ask for the money, we're going to pay you, these employees, we're going to pay you $350 for the year to sign this contract. And by doing that, we're basically, getting out of all the problems.
But they're paying $1,000.
So I must what?
They're not paying you. Saying
I'm assuming. I think choice number 2 doesn't make it clear. I think choice number 2 means that they're not gonna have to pay the $1,000 and only take $5 for the profits of the day. But why is it theirs if they're not paying? You're saying?
Well, I guess they pay 10 really because it's a down payment, and then if they elect option 2, they get
Right.
$350 back.
Right. Correct. And then you see everything here. Now, does it say anything about this lease shall be enforced 4 days ago? The lease and purchase was effected and finalized concurrently here according to Jerusalem by virtue of this document. You see the bottom paragraph?
Yeah.
So the very end, it says that there was a handshake, there was a kinyan sudar, there was a down payment. That's to make it binding in halacha.
I guess liability.
Well, the language in here that if the business doesn't generate a profit, then the payment is not due. So
Right.
You can just say
There was no profit. Right. Also, due to lessor's fear that the leasee may depreciate the value of the business, so you're saying this is not enforceable? You're saying? You think?
I was not coming to that conclusion, but I thought that there would be
It's something to talk about.
issues
Right.
because there's so many
Ins and outs.
caveats and clauses that make it where like the lessee doesn't really have any rights of a traditional lessee. Like,
Well, he
they
can
really don't.
technically.
Except $5.
No,
So
or
if-
within 24 hours he can demand the full accounting.
Oh.
He has the
Yes,
choice.
he could. And then he would have to pay the $1,000
Right.
in order to get the profits.
Yeah, right. You're giving him that choice theoretically, but you threw in there that it's up to the lessor to determine how much profit was made.
Yeah.
It's like that joke with the rabbi that he's they're hired by the shul, so he's like trying to figure out like what's the price of the rabbi. So they said anything to do with ruchnius is the rabbi. Anything to do with gashmius is the board. And the board decides what's ruchnius and what's gashmius.
I heard the other way around.
Oh, yeah.
Rabbi Lev said it. He said, I choose, I decide.
Well, I'm saying because he was, yeah, okay. Yeah.
But if I decide that the painting on the shul should be yellow is a ruchnistic issue.
Okay, fine. That's his, yeah. But right. Okay, so the point of this one, you see, this is a lot more. This one has to have a lot more in here for 2 main reasons. Number one is it's not a real partner. So they don't really feel like giving the partner anything real. It's an employee that they're trying to just give it to them for
Does it
Shabbos.
have to be an employee?
It has to be someone that it makes sense for them to be in the business. They're there. They're on the site, technically. I don't guess it doesn't have to
Why can't
be.
lease it to anybody?
You could.
It's like if you want to bring it in your partner.
You could, but you're right. You could. but the point, it wasn't a real partner. Like the other two cases, it was a 50% partner and a 20% partner. So it made sense. This one, the guy's not a partner at all. B, it happened already after the fact. So therefore, you couldn't make an arrangement like this where we don't own it we only own 80%, you own 20%. Because theoretically what you could do is you could bring in the employee and say you own 20% of the business, but if you don't do an accounting, we'll give you $350 for your settlement. I mean, you could do the same thing.
Give an incentive.
Right. So you could technically do the same thing on it, but since this was done after the fact, so this was the only choice.
What is the lessee trusting the lesser about on his word alone?
The accounting of the profits.
Why would he need to trust him?
Because then he can't say I want to look at the books to determine it myself or have an accountant do it.
Oh, I see. It's a little complicated.
What?
No, it's complicated back and forth.
It's a little bit of a...
Make it so complicated that the lessee can't possibly enforce his rights. He doesn't even know what rights he has or she has.
To hire a dominant attorney.
Yes, it's just to determine the... No, so I thought this was interesting. Now, it happens... These are pretty much all real cases. This one, they obviously went back to their attorney. They wanted it to be really part of the... they wanted it to be pretty real. The other ones, again, I guess it was also reviewed because it was part of their partnership agreement, but it was with real partners, so it was just an understanding, and that was that. Just on a practical level, a lot of times people will go into some sort of partnership. You really have to know, they may ask this. So I wanted to share it with you, so to have it and see if it's. If it ever comes up, it's something to...
No, it is very interesting in terms of seeking ways to, modify these templates, and, even Josh came up with an idea as to one of the documents.
Right.
And I guess... no, not even. I meant now, like on the spot. That's what I meant, not you. But I guess another question is because the issue is really halachic, in terms of the Schar Shabbos issue of making money on Shabbos,
and the employees working.
So are these even meant to be enforceable in secular court, or is it more so?
Well,
this is the idea behind these.
The idea is
for Beis Din.
The idea is it's not even Beis Din. It's really for it to be true. Enforce,
But I guess
correct.
In the event that there's
Here
issues
says,
with it, issues
right.
between
There's
the
issues
non-Jewish and Jewish people involved in the agreement, I
Right.
guess it would have to be actually in that case.
Right. This contract, it says here, I don't know if this is true, but it says this contract is legal and binding in Jewish law and secular law. I don't know what they wrote that. I mean, I don't know if that's true or not. But
yeah, because if any non-Jew would seek to enforce it, maybe there should be an arbitration agreement that if there's any dispute over these contracts, that it should go to Beis Din.
Yeah.
That would be something that you could add to make sure that it only goes to Beis Din. To say that, to the extent that there's ever a dispute relating to anything in this agreement, that it will be exclusively arbitrated before, like a particular Beis Din, or just Beis Din in general.
On the way here, someone called me up, and on that point, someone called me up and he said that you should share in your class, if you're going to talk about dispute resolution and Beis Din, so you just brought it up, that it's worthwhile putting in that if one of the if both parties are from Florida, then it won't matter. But if one party is from let's say out of state, from New Jersey, for example, and the other party is from Florida, and this guy just had this case, and they put in the dispute resolution that they're going to go to the Beis Din in New Jersey, but the partner from Florida assumed that if they go to the Beis Din in New Jersey, he would be on Zoom. But because the other guy's in New Jersey, they wanted him to be there in person. So, or the Beis Din, something like that the other person had the right to demand that he come in person. So he said, if that's the case, you should put in there that it's by his discretion if he wants to be there by Zoom, in person or not, because he said he's just running into this right now.
It's becoming an issue in secular courts also, because before you had to always come. If you were a plaintiff, you had to come to Florida and here. But now with Zoom, like we have a case right now, they're in Uzbekistan, they're 7,000 miles away. So far the judge is like that law is almost outdated because Zoom now makes it...
Right. But sometimes one side may demand that the person come.
That's leverage. Well, we demanded, but the judge is like, no.
Exactly. That's what I'm saying. So he said, sometimes it will come up. It's worthwhile, throwing that in there. But anyway, all right. So that was that. Any questions on that? Or?
Do you have word versions of these?
Yes, I'll send. I'm going to collect these, and I'm also some of the other stuff that we had. And I'm going to make a folder, a halachic documents folder, and have it in format so you can edit. So I'm going to include in there the dispute resolution clause. I put on the chat if we had it. I found one. I found it, but I needed it. I'm not going to put a heter iska in there because every heter iska needs to be reviewed carefully. So it's worthwhile. Just send it to me if you have one. But I just did 2 or 3, and the this last piece about enforceability, kinyan sudar and all that. So I'll put some stuff in there and we'll share it. All right.
Thank you.
Okay. Shkoyach. Everyone have a good year, Mr. Shem, and continue, doing the right thing.
Seeing you as well. Always a pleasure.
What happened with that court case?
I actually didn't talk to Josh. We're supposed to go to basement, and I sent the client an email about paying the upfront costs, and I haven't heard back. I'll follow up with them.
It still hasn't happened?
No, it's not happening.
Are you serious?
It just, that's not unusual.
Wait, I thought that was the next question.
No, we haven't even started the investment process. Once we started, I think it'll go quick, but I don't know why.